doesn't the causal complexity concern the causal complexity that would face courts if the rule were otherwise, not causal complexity that is limited to the situation where there is what you call an on-the-spot arrest?
It concerns courts, right? Because you don't want judges second-guessing what police officers are doing when they're making very difficult decisions, whether to arrest a suspect, whether to remove the suspect from the streets, and they also have to communicate to the suspect.
But that exists whether or not it's an on-the-spot arrest. The causal complexity exists in all of the class of cases that Nieves was talking about. And when the court was stating what it held, I don't see a reference to split-second decisions. The court says that Nieves and Wright argue that no probable cause, there should be a no probable cause requirement. Their primary contention is that retaliatory arrest claims involve causal complexities akin to those identified in Hartman. As a general matter, we agree. And later, when it's stating the holding, because there was probable cause to arrest Bartlett, his retaliatory arrest claim fails as a matter of law. I don't see reference to split-second decisions.
Your Honor, on page 1725, you make reference to split-second decisions when you're explaining a particular type of causal complexity here, where an officer has to make a decision whether to arrest, and in that moment has to take speech into account to determine whether the suspect is ready to cooperate. And that very example also appears in Reichel. That very example also appears in Lozman. This is the causal complexity that is particularly difficult to untangle. Other causal complexities, and with, of course, with prosecutors, you have your own separate problem where you need to actually talk to a prosecutor to determine what the prosecutor was thinking, and that second-guessing those decisions is also difficult. But the kind of causal complexity that's present here is very similar to the causal complexity in Mount Healthy. Mount Healthy created the burden-shifting framework to ensure that we can disentangle proper considerations of speech from improper considerations.
Do you have a reason? I assume you do have a reason for stressing this argument rather than your other argument that the Fifth Circuit understood what was needed to prove that the case fell within the exception too narrowly.
Your Honor, we would be happy with the objective evidence carve-out as well if it were if this court allowed objective evidence of causation to come in other than what the Fifth Circuit is talking about, which is a very specific comparator of non-arrests. But our position is that Nieves covered the vast bulk of cases, and those cases involve on-the-spot police officers having to make very difficult decisions. On the one hand, you only have mere allegations of state of mind. On the other hand, you have probable cause. And this court said that in those types of situations, we're not going to put police officers in this very uncomfortable position.
But are you making this argument because you have bigger fish to fry, or because you think this is the argument that's most likely to succeed in this case and serve the interests of your client?
We're making this argument because Ms. Gonzalez's case clearly is not the kind of case that the court was concerned with in Nieves. This case is much more similar to Lozman on the facts, and in that case you said that Mount Healthy rules should apply. That said, Your Honor, there is a way to we would be happy with the Fifth Circuit reversal on either one of the questions presented.